As you may or not know, my name is Carolyn Croming. I'm a licensed attorney and have been for the last 17 years and practice only construction law. And even before that was involved in the construction industry growing up. And I have to say, as employment law goes, I really didn't have any background or any experience in employment law until I started practicing law, right? And I ran into several situations over the course of the year where, although I had a construction company client, we had employment issues that we had to deal with. And then looking at the severity of those situations and how they came about, it became very clear to me that not everybody understands these rules or how they are out there, because I know I didn't. And I know the people like my uncles, when I was working for them, they had no idea, right? And it really doesn't become an issue until you get in trouble. And my whole point is to help you not get in trouble, because when it becomes an issue, it's not a small one, it's a big one. And so this is, letting you know all of these things on the front end to help you see why, or to cover your ass, so you don't end up in the situation that you have very little control over at the end. So that being said, especially in the construction industry, you can go to the first slide, Hannah, please. Thank you. We're always in a constant question. Do we have employees or do we have subcontractors? Now, throughout the presentation and everywhere else you'll see, we refer to independent contractors. In the construction world, usually what that means is a subcontractor, like somebody that is not employed by us, that is working for us, that does work, but is considered an independent contractor. And so those are the two types that we're dealing with, and the rules regarding each of them are very different. And so the main thing is we're going to talk about how do we classify them, what things we look at, and then what happens once they are classified. All right, so the main thing I want to dive into is that at the end of the day, you're doing it right, sorry, thanks, is that what you want to call someone or what someone wants to call themselves, either an employee or subcontract, is not what matters, right? We're going to go over through what the law says and who makes that determination. And so if we get to the stage where we classify somebody as an employee, the rules that regulate overtime, all of that stuff is under the FLSA, the Fair Labor Standards Act, which was actually started in the 1920s to keep kids out of factories and 90-hour work weeks, but has evolved since then, right? And so some of those are overtime and all of that. And they apply once you decide that or we decide that you have employees, it doesn't automatically apply. You still have to be under the federal law, which is the FLSA. And so we're going to go over the standards, which will cover most every company, right? So the first one is enterprise coverage. So if you do over $500,000 gross income in a year, and you have employees, you will be under FLSA, meaning overtime and all of that applies to you. So that's the first way you get in there, is if you're over $500,000 a year in gross revenue, right? The second way is if you don't make this, the second way you can be covered under FLSA is that if you're involved in interstate commerce. That's the next slide, Hannah. And interstate commerce can be something as far as you buy products from out of state. You deal with vendors that are out of state. So if you're not covered by the first one of $500,000 a year, you're most likely buying some kind of product or sending an email to somebody out of state. So you would be covered by the interstate commerce rule. So meaning if we get to the point where we look at the classifications and determine that you have employees, you're going to be under the FLSA and having to pay overtime and follow all of the rules that are under the FLSA. Okay, so some of the things that if FLSA applies that will apply is any employee who works over 40 hours in a week needs to be paid 1.5 times their regular rate for any time over 40 hours. Okay, and this is important to know that even if you pay on a 2-week cycle, each week is determined by itself, right? So you want to say 80 hours in a 2-week period. That is not the case, because if they're working 60 hours in 1 week and 20 hours in the next week, you owe them for the overtime over 40 in that first week. So you can't get around the 40 hours a week by doing a 2-week payroll cycle. Each week is considered on their own, right? So now there are some exemptions we'll get into of people who are not entitled to overtime, even if there are employees, but it's based on their level of pay and a bunch of other determinations that if we have an employee, are they exempt? And we'll get to that here in a little bit. So like I was saying before, who gets to determine if someone is an employee or a subcontractor? It's the courts and the rules and the laws, and there are laws out there that make that determination for you. And so on the next slide, it can never be just, an easy yes or no, or what are we looking at? There's a 5-factor test that is generally looked at to determine if someone is an employee or a subcontractor. The degree of control exercised by the employer. So how much do you control what that employee or subcontractor does? Do they work for other people? Do you tell them to be at the office from 8 to 5? You tell them exactly what to do. Is that, how much control do you have over that person? Could they say, no, I can't come to work today and go to another job? So this is the biggest element that they're looking at. How much control do you have over the person you're trying to claim as a subcontractor or an employee, right? The more control you have over a person, the more likely they are to be an employee, right? So, if they're only working for you, if you're telling them exactly what to do, and here's our manual, here's what you're doing from 9 to 5, then most likely they're going to be an employee, right? The next one, the permanency of the relationship. Is it just you they're working for or somebody else? That's a big one too. And another thing too is, are they an entity or is it an individual, right? If you hire an entity with a contract, that is a lot of evidence that your control over them is limited to that contractual relationship, and it's an LLC, right? The fact that they may work for other people and you're not the only one on their schedule is definitely looks more like a sub than an employee, right? So these are all the relative factors that are going to be looked at when somebody makes a determination of, are we an employee or are we, a subcontractor? The skill level involved, the higher the skill level, the more likely they would be determined to be an independent contractor. Like the guys that build your website is going to be an independent contractor because it's a very high, a skill that somebody has, and a lot of subcontractors are true subcontractors that come in and do their one job on your project and then they move on to the next one for another builder. So, if, are they a licensed plumber? Are they licensed HVAC? If they're licensed, it's more likely they'll be considered that they're an independent contract. So, and then who's paying for the overhead, right? Do they have their own tools? Do they have their own truck? Do they have all of their own stuff? If you're providing that, it's more likely that they're going to be an employee. If they have their own stuff, their own truck, their own tools, and they just show up and do the work, it's more likely that that they're going to be a subcontractor as opposed to an employee. And the potential for profit and loss, right? If the subcontractors gets paid the same way on every job and they bid the job wrong and they're going to lose their own money, then it's more likely they're going to be a subcontractor. If they get paid the same, like an hourly rate, no matter what, then it's more likely that they're an employee. So who's going to take the risk of loss? Like a sub is going to bid the job himself, give you a price. If he misbids, he's going to have to eat it. If he's an employee just working an hourly wage, the more likely that they are an employee. So these are the factors that you should consider when you're determining is somebody an employee or a subcontractor, because these are the factors that a court would look at to determine that. And so, although, you can go to the next slide, although they consider all 5, the element of control is the most influential, right? And like I said, if you can show that it's either working for other people, you're not the only one that's in control of them, they show up on their own time schedule, all of these things would show that they were a subcontractor and not employees. And so the other thing too is, like, if once we make it through this test on the federal level for like FLSA, that's cool. There are some states like California that have more stringent rules. So like in California, even if you classify somebody as an employee, I mean, as a subcontractor under the federal rules, they could still be an employee under the state rules and be entitled to overtime and all of that. So it is a state specific determination as well. So you need to look on both the state and Texas laws are the same as the federal laws. So they're pretty much the same. In some states, the states have, more requirements where someone would be an employee as opposed to a subcontractor, and more, times that somebody would be entitled to overtime. Okay, so one of the big things too is that, okay, you say you have an employee, we're just going to pay them salary and we don't have to worry about overtime. That is not the case. Even if you pay them salary, the general rule is they would be entitled to overtime for any time they work over 40 hours. So if someone is salary, technically you still have to keep track of their time and then pay them time and a half over 40 hours a week, right? Okay. There are some exemptions to this rule, right? That you have an employee that can be exempt from the overtime requirement. And I would just tell you, as the higher they're paid, the more higher position in the company, the more likely they are to be considered exempt, right? If they have people that directly report to them, if they are in control of a whole department, if they are a manager and actually manager and controlling people and decisions, then the more likely they will be an exempt employee. And if you're an exempt employee, you do not have to pay overtime. So the salary would be fine for an exempt employee. So like a C-suite position, obviously, a manager, a head of department that's managing several people would be exempt from the overtime requirement, and paying them salary would be enough. But for your clerks that answer the phone, salespeople, all of those people generally are not, warehouse workers are not considered exempt, and they would be entitled to overtime even if you pay them a salary. All right, so those are kind of the general rules, and I don't have a slide in here about this too, but if you decide that someone is a subcontractor, right? Having a subcontract is important. Number one, it helps clarify the relationship. They are a subcontract, they signed a subcontract agreement. It helps define the terms of what they're hired to do. I see case after case where subcontractors come back and say, no, I was hired to do this and you didn't pay me. And we don't have any documentation to prove or disprove. To get insurance information from subcontractors, right? If you truly have a subcontractor, having a subcontract agreement, having them sign it, getting added as additionally insured is hugely important. And the additionally insured thing I like to bring up, because if you're not listed as additionally insured, you cannot file on someone else's insurance policy. The rule of insurance is only the insured can file on their own policy. So say you hire a sub. I had this happen actually once. He was putting in a wine closet in the basement and hit a line in the middle of the weekend, a plumbing line, and flooded the entire house, right? If that sub left town, even if you had a certificate of insurance, you could not file on it. You'd have to be listed as additionally insured. How it's supposed to work, something like that happens, you give it to the sub, he turns it over to his insurance company and makes a claim, which is generally what happens. But sometimes the subs go out of business, you can't find them, it's been years, and if you weren't listed as additionally insured, you won't be able to make that claim. So another reason why subcontract is important if you are truly using subs, liability issues, right? So if an employee gets hurt on the job, you're responsible. You need to have workers' comp. If a subcontractor gets hurt on the job, they're in charge of their own employees and their own damages and stuff like that. If we don't have a subcontract, or even if we do have a subcontract and all of those other elements they still look like an employee, they may be able to get around that, and then you're going to be responsible for somebody getting hurt on the job, right? And so all of the same elements we're looking at, we need to make sure we have all of those elements and there is a subcontract, because that's really going to nail it in. Hey, this guy works for somebody else. Here's my contract with him that he says he's responsible for his own guys, his own equipment. He's going to follow the OSHA rules. He's, all of that is in there that he's in charge of, because I've seen it happen time and time again. They may truly be a subcontractor. Somebody gets injured on the job. We don't have a subcontract. and they will sue you and claim that they're an employee because we don't have anything. And we may eventually prove that they were a subcontractor, but it's a much longer and harder fight without a subcontract. So I didn't have any slides on that on the subcontractor side, but I think it's important that if you truly do have subcontractors, that you have a master subcontract agreement. We do them here for a flat fee of $2,500 if that's something you need. Okay, so we went over the classifications of subcontractors and employees and the elements that were looked at. And this becomes important because if we misclassify an employee, it's a big deal. Okay, we misclassify an employee and somebody figures it out, or we somehow gets onto that we're not paying the wages properly. It can be a big deal and huge penalties. So what are some of the things that can happen if you misclassify your employees and it comes to light, or you cannot even be doing it. Can you go to the next slide, Hannah? You could not even be doing it on purpose. It's just that you didn't know it better. So we're talking about violations, penalties, interest, lawsuits, investigation by the Department of Labor, class action lawsuits. And these are the things that I didn't realize, and I'm sure you don't realize that if we get it wrong, it can be very painful. So one of the big things is, if you go to the next slide, if you're sued in a wage overtime case, you're sued in federal court because it's a FLSA violation, right? And so part of the FLSA investigation is when you're sued, there's an automatic investigation into your books to see if anybody else potentially has overtime claims for the last 3 years. So you're going to have to turn over your records for the last 3 years. If they find somebody in there that potentially has an overtime claim that you didn't pay, they're going to send them notice and give them an opportunity to join the lawsuit in federal court. Once this federal lawsuit is started, there's no way you're getting out before that process happens. The court's not going to let you out. The other side's not going to let you out because they don't know how much money is at stake. And most of the attorneys that take these kind of cases are contingency fee attorneys, meaning the larger the pot that they can find, the more money that they're going to get. So once this happens, we're latched on for at least that far before we can figure out how much we can pay them to go away. And so you can also, once we determine an amount that you're owed, it could be double the amount. You could have to pay interest, have to pay attorney's fees. It's not just as simple as dealing with this one employee, right? It can be very expensive, very time consuming and stressful, right? Because you don't know exactly what's going to happen. You don't know exactly how much it's going to cost. And that's just a lawsuit, right? There are other things that can happen because of this, right? And if you do it more than once, then each time the penalties increase. So, if you get caught once, you fix it and you're good, then you won't have a problem. But if you don't fix it, there's huge penalties for that too. Another thing that can happen, so you got the federal lawsuit against you about wage and overtime claims. You also have the Department of Labor that can start investigating your books and having to turn everything over and forcing you to pay them penalties and interest on top of the lawsuit. Nobody realizes how stressful and how at heart it is to deal with this kind of stuff when you're just trying to get a job done. I get it, and I can only tell you this stuff because I've been through it, and it's painful. And it's worth a little bit of investment on the front end to not have to do this. So real life example, and most of these things, in my experience, either start by somebody getting hurt on the job or somebody getting in a car wreck, and they go to an attorney for their personal injury claim. And the personal injury attorney starts sniffing around and asking them about their job, how they're paid, and then at the same time, so they either take it in-house or have another attorney they refer to is the overtime claim that can be filed against you. There have also been examples in the past where somebody comes and works for an employee for a company and knowing very well how they pay and working there for a while, and then making this type of claim. Because people can make a living out of making money this way if you're going to do it the wrong way. And then they also let everybody else know that that's what they're going to do and that they have the same rights. So it becomes a lot more than just that one person. And so this example is, even if you get somebody to waive their right to overtime or say they're classified as a subcontractor, if they're not, it doesn't matter. They can't waive their rights. You can't pay them but anything like an employee. So, I had that happen. They let the employee waive his rights and say, yeah, I don't want to be an employee. Still got sued, still went through the whole process because they relied on them. They could do that. You can't do that. So just know that you can't have an employee waive their way out of overtime claims or stuff like that. Okay, some other things in the employment realm that I want to talk about real quick are restrictive covenants, or also known as non-competes. Okay, and so there's some different types of agreements. Non-compete specifically means that your current employee will not leave you and go work for a business that does exactly what you do, doing what they do, right? That's what the non-compete means, or they won't start a business doing that same thing, right? Non-competes, generally speaking, in order to be enforceable, have to be very narrow. You can go to the next slide, Hannah. What does that mean? Okay, they have the geographical area of where it can be limited to. So like if you have someone who's a salesman for your company in Houston, and they go get a job for a competing company in San Antonio, it is highly unlikely any non-compete clause would be enforceable there. You could maybe get Houston and maybe surrounding counties for a period of 6 months or less, right? In order for these things really to be enforceable, they have to be small in area and short in time. And honestly, if it's a low-level employee, the likelihood of it being enforced is very low, right? Like if you have a CFO or something like that, then yes, it'd be enforced. It'd be likely to be enforced. But if we're talking about somebody that makes $12, $13 an hour and you're restricting their right to work, it's not really going to be enforceable. And now I have clients all the time, I tell them this and I still want to do it anyways, just so people think that there's a non-compete that's enforceable. And honestly, non-competes just generally are there, I think President Biden has gathered task force to see if there should be a law to outlaw these things at the federal level anyways. So these non-competes as a general rule have a hard time. So just be wary of that. There are other ways for you to protect your business besides a non-compete, right? And so some of the other things you can do is a non-solicitation, which basically means that once you leave, you can't take my clients, you can't contact my clients, that you can't do. And those are generally upheld, right? So that's one of the things that you can do. Another one that you can do is a confidentiality agreement, right? That's another way, is that the information you have is confidential and can't be taken. So there are things in agreements and employee handbooks that you can put in there that will protect your company, that will work a lot better than a non-compete, right? We can put the non-compete language in there, but I don't think that's where you hang your hat unless we're talking about a high-level employee that has a lot of impact at your company, right? If not, we're looking more at non-solicitation, confidentiality. And the other thing is too, is can you go to the next one, Hannah? Might be unreasonable restrictions on the non-competes. We're a couple slides behind. There we go. Next one too. Best practices. If you really are interested in a non-compete or something like that, have a conversation with an attorney, because you may not want a non-compete. It depends on what your goals are and what you're trying to do, and we can usually write something into what you want to do, whether that's trade secrets, confidentiality, not taking your clients, but just called it a blanket non-compete is going to have real issues on enforceability. Whatever you do, don't get one off the internet. I promise you, it'll be more of a headache than it's worth. Let's have a discussion about what you're really trying to do. Another thing that is out there, and you don't have to do anything to register or anything, the Texas Uniform Trade Secrets Act. So even if you don't have an employee handbook or an agreement or anything like that, if there are things in your businesses that people have limited access to, like a customer list or a price list or something like that, that only like the core people of very few people, it's like kept someplace else where not everybody can get it, then it's protected just as a matter of law if we can prove those things, right? And if somebody takes those and use them against you, you can go after them whether you had an agreement or not, right? But we have to show that there's it's separated, it's not accessible to everyone, and that it's truly a trade secret. Another cause of action that you can have without an agreement is tortious interference. And this was what I've actually had a case where somebody is a current employee, starts a competing business with their employer, and starts taking their customers while they're still working for the existing company. That is tortious interference, and that is illegal. You as an employee have a duty, whether it's in writing or not, to do what's in the best interest of the company. And having competing business and stealing clients and taking money is obviously not in that best interest. So even if you don't have something in writing, something like that would be illegal, and you could take legal action to stop it. So how do you protect your business? How do you CYA? You have employee handbooks. You have confidentiality agreement. You're upfront about the fact that, hey, in this role, you're going to be exposed to things that are not the general public and are important to our business's success. And we expect that upon you leaving or going to do something else, that the information stays here. It is not something that's public knowledge and that you give to anybody else. So confidentiality agreements are generally enforced, whether they're in a subcontract or in an employee handbook, right? So if you're in business, and whether you have employees, can you go to the next slide, Hannah? Whether you have employees or you have subcontractors, documentation is key, and keeping the documentation is key, right? The subcontract agreement we talked about, the handbook, man, is super important. If you have employees, describes overtime policy, describes all of the other information, and we go into a list on the next thing of things that you would want to have written policies on, that you have your clients. Can you go to the next slide, Hannah? Written policies on that you would give to your employees on the front end. Just to be, these are our processes, these are the things, here's our discrimination policy, that having this stuff, trade secret agreements, having this stuff on the front end for a minor investment will save you so much, unemployment claims, EEOC claims, which we'll get to that in a second. Having all of this stuff, I promise you, the small investment, you take the time to do these now instead of later, it will save you a lot of heartache and a lot of time. Paperwork, and so all of these things are to CYA to make sure that you're taken care of if something goes south, right? Another thing is discrimination claims, that an employee is being treated unfairly because you're discriminating against them. Having these things, that you have a discrimination policy, that all of these things are taken care of, because an EEOC claim, so if somebody has a discrimination claim, it's normally a claim filed with the EEOC, and you have to answer it just like a regular lawsuit and prove yourself, and having a handbook that has this stuff in there is hugely important, can help end the dispute right away. Another thing that is hugely important, just from, can you go to the next slide, just from a practical standpoint, as being a boss and being an employer, is job descriptions and performance reviews, right? If a person knows what to expect, just like in any relationship, they're going to do better. They're going to know better. This is what's expected of me. This is what I'm supposed to do. And hey, if there's an issue, we have a job description that says this is what is expected. This is what I'm supposed to do. If there's an issue, you can be like, hey, remember when you started signed up with this job description and you said you would do this. Yeah, well, this is where you agree to do it, and this is what I need you to do. So, and then it becomes very clear if an employee is or is not doing what they're supposed to do, what they agreed to do. And then, quarterly performance reviews, or what I do is 30, 60, 90 when they're new hires, and then it's twice a year after that. So you just keep them updated on how we're following the processes, which would become helpful later on if there's any discrimination claim. No, look, they've had a performance issue since they started, and here's where we document it, and here's where we try to help them become successful, right? EEOC and discrimination claims are looking for what opportunities, if you really fired them for cause, what opportunities did you give them to correct that? When did you tell them that, right? That's for EEOC claims, that's for unemployment claims, all of this stuff. It's very important. Like, here's their performance reviews. Here are all the things I told them to improve. I gave them another chance. They still didn't, and I need somebody to do this job, so we were forced to hire somebody else. So from having successful employer relationships, these are important documents, just, so people know what to expect and to see why if something happens later on. Again, EEOC complaints, discrimination claims, having a policy in your handbook of how those things would be handled, and that you're a non-discrimination employer, and to provide all that stuff if something happens. Getting it after the fact is helpful, but it's super helpful if you have it way before it's ever an issue, right? It's helpful if you're getting it after the fact will help you for the next time. So take some time and invest some money and get this stuff done now. So again, unemployment claims. Right now, unemployment claims are generally hard to win anyways, but right now they're extremely hard. So having proper documentation, written attendance policy, timesheets, what is your PTO policy, what is the hours, when are they required to be there, all of this stuff. The more you can show, the more times they were given to correct their behavior before they were fired, the less likely you will end up having an EEOC claim or having to pay unemployment. So I hope I've shared some valuable lessons that I've learned for myself and my clients, and that I hope you don't have to learn them the hard way, because they can be extremely time consuming and expensive. So I'm here if anybody has any questions. Hannah, you there?
Yeah, I'm here. We are opening the floor now for a Q&A if anyone does have questions. Wait a few minutes, please do. We got finished a little early, so definitely have time for conversation and engagement.
Hey, Carolyn, this is Crystal in Connecticut. How are you?
Good, how are you?
Not too bad. I just wanted clarification on something. If you hire a subcontractor, the 1099 person, and you do utilize them as an employee, you're directly controlling them every day, so and so forth. Is that actually illegal, or only if you don't offer them overtime or comply with all of the other things with fairness to employees?
As long as you're doing the overtime and following everything, like the fact that they were a subcontractor and changed into employee, or they're treated as employee, it wouldn't matter. And
then we would also cover them on insurance as well, I believe, right? Like if something ever happened to them, they would really be.
And truly, if they're an employee, we should have workers' comp.
Okay. All right. Sounds good.
Yep.
Thank you.
Uh-huh. And if you guys think of anything else, I'll be around. You can send me an email. I just don't like to be so long-winded in this stuff. I like to get right to the point.
Yes.
Some of you guys got busy lives too. And plus, I don't know how else to say it. I could try to make it longer, but I'd just be saying the same thing over and over again.
Exactly. As Carolyn said, we will be following up, and feel free to reach out directly for any questions, or get a free consult as well. I'll be sending out the presentation as well as the handout, just for you guys to reference, and then this will also be recorded and posted to our YouTube account. So let us know, and thank you so much for everyone for joining.
I have a question.
Oh, great.
Yes, sir.
Regarding employee handbooks, this is Darren out of New Jersey. Do you have employee handbooks kind of already done that can be crafted towards New Jersey with our business information on it for our employees?
Yeah, we have them specifically for your state and for the things that are required there. And I think ours are 3,500.
Okay.
But it's
so
it's going to be like you hire us, we're going to send you a questionnaire, kind of how you want to handle, overtime, how you want to handle PTO, attendance, and all of that. And then we're going to craft that with your requirements and the requirements of your state.
All right, thank you for that. So you helped me with changing my terms and conditions, so I appreciate that and looking forward to working with you further. I currently do have job descriptions with a lot of that detail in it, but you're saying on top of that, we need to have an official employee handbook?
Yes, I do think that would be helpful for your other things. I mean, okay, question, do your job descriptions go things like your PTO policy, discrimination kind of stuff, FLMA?
Yeah, I mean, I don't remember if the FLMA thing is in there, but we tried to cover the basics that we knew of.
Gotcha.
And a lot of it. I know we're probably missing something because I can't keep up with all this stuff.
No, I know. And so I'm trying to help you so you don't have to, because I know you're trying to run a business.
Yeah, agreed. And then you could also in that, deal with, because I do have some of the non-compete stuff in there currently, and I missed a
Yep.
little bit portion of this, but you can help go through that as well.
Yeah, and we'll see what's enforceable in New Jersey because it is state specific.
Okay, great. And then also this webinar that you did today, if you don't mind, is that good? Are you going to have a recording of this that we're going to get? Fantastic.
Yeah, I think Hannah said we're going to email it out.
Yeah, I will send a link to the recording once I post it today.
All right, fantastic. Thank you so much. Appreciate it.
Thank you. I appreciate it.
Any last call for questions, conversations? Speak now or forever hold your peace.
You can call us later. We'll be around.
Yes, but thank you guys so much for joining. Thank you, Carolyn, for the webinar. We'll follow up and talk to you guys soon.
All right. Thank you, guys.